Hello and a warm welcome to All This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notifications for new videos. My name is Sheetal Joon, Associate Editor, latestlaws.com, and I will be taking you through the significant orders and judgments passed by various courts in the country and some important international news from this week. Let's begin with Supreme Court this week. The Supreme Court in a landmark judgment has held that the Enforcement Directorate and its officers cannot arrest an accused under Section 19 of the Prevention of Money Laundering Act (PMLA) after the special court has taken cognizance of the complaint of money laundering. The division bench of Justice Abhay S. Oka and Justice Ujjal Bhuyan added that if ED wants custody of such an accused, then it would have to apply to the special court. The court also held that the complaint filed under Section 44(1)(b) of the PMLA would be governed by the provisions of the CrPC. Therefore, if the accused wasn't arrested and the cognizance was taken, then a normal rule, the accused would be summoned and not warrant. In a major ruling, the Supreme Court has held that advocates and lawyers cannot be sued for deficiency in service before the Consumer Court as service rendered by them are not in the ambit of the Consumer Protection Act 1986. The court stated that it is important to keep a distinction between professionals and somebody carrying out a business or trade, while stressing that the legislative intent of the Consumer Protection Act is certainly to leave the professionals out of its scrutiny. The court also observed that its 1996 judgment in Indian Medical Association versus VP Shantana, whereby doctors and medical professionals were added under the ambit of the Consumer Protection Act and negligence became the basis to drag them to consumer courts, needs a revisit. The Apex Court has stressed that the power to arrest is far more intrusive and consequential than the authority to investigate, reminding law enforcement agencies that the law does not mandate an arrest in every case where an investigation is necessary. Highlighting the fundamental difference between the power to arrest and the power to investigate, a bench led by Justice Sanjeev Khanna observed that while investigating authorities have the duty to uncover the truth, the power to arrest must be exercised with greater caution and discretion, besides being in complete adherence to the letter of the relevant statute. The court's observation came as it reserved its judgment on a series of petitions related to arrests under Central Goods and Services Tax Act (CGST). States have corresponding provisions under the state GST laws. The Supreme Court in a major ruling has expanded the scope of Pankaj Bansal judgment to the accused arrested under the UAPA, as it held that the provisions regarding the communication of grounds of arrest to a person arrested contained in Section 43(b)(1) of the UAPA is verbatim the same as the Section 19(1) of the PMLA. A division bench of Justice B.R. Gawai and Justice Sandeep Mehta with the observation held that the arrest of NewsClick founder Prabir Prakyashtha as illegal for non-supply of grounds of arrest to his counsel. Any other interpretation would be tantamount to diluting the sanctity of the fundamental rights guaranteed under Article 22(1) of the Constitution of India, the court stressed. The Supreme Court has ruled that the compulsory acquisition of private properties will be deemed unconstitutional if proper procedures are not established or followed before depriving an individual of their right to property. In a significant verdict, the top court said that even the statutory scheme of payment of compensation in return for acquisition of private properties will be not justified if due procedures is not followed by the state and its instrumentalities. While making the observation, a bench of Justice P.S. Narasimha and Justice Aravinda Kumar dismissed appeal of the Kolkata Municipal Corporation. Article 300A, right to property of the Constitution, says that no person shall be deprived of his property save by authority of law, and it has been characterized both as a constitutional and a human right. Now let's have an overview of High Courts. The single judge bench of the Jharkhand High Court has held that summons in a criminal case to face trial cannot be issued against positions or post, as a post is not a juridical person. Therefore, taking cognizance by not naming any person who was responsible for the alleged criminal act is certainly not sustainable in law. The court observed that since a post is not a juridical person, a summon in a criminal case cannot be issued against position or post to face trial, as it is unsustainable from a legal standpoint to take cognizance without naming the individuals accountable for the alleged criminal act. The single judge bench of the Andhra Pradesh High Court has held that it is only in cases where the civil suit is for possession or for declaration of title in respect of the same property, and where reliefs regarding the protection of the property concerned can be applied for and granted by the civil court, that proceedings under Section 145 should not be allowed to continue. This is because the civil court is competent to decide the question of the title as well as possession between the parties, and the order of the civil court would be binding on the magistrate. The High Court of Calcutta, while allowing a petition filed seeking quashing of a criminal case, observed the dependency of an eviction suit between the parties is a civil dispute and cannot be ground for quashing a criminal complaint. The court observed that the High Court has no jurisdiction to appreciate the evidence of the proceedings under Section 482 of the Code, as contradictions and/or inconsistency in the statement of witnesses is essentially an issue relating to appreciation of evidence which can be gone into by the trial court. The single-judge bench of the Andhra Pradesh High Court has held that in each case, the need to appoint a commissioner is to be independently examined, even if there are any private service conducted. Since it is allowed subject to objection by the other side, it is safe to appoint a commissioner if at all measurements of any property is required. The court observed that the necessity of appointing a commissioner must be objectively assessed in every case. If a measurement of any property is needed, it is safe to appoint a commissioner even if private surveys are carried out, since it is always subject to opposition by the opposing party. Moving on to international news this week. Nepal Supreme Court has limited numbers of climbing permits for Mount Everest. The Himalayan Republic is home to 8 of the world's 10 highest peaks and welcomes hundreds of adventurers each spring when temperatures are warm and winds are typically calm. The verdict summary said that the mountain's capacity must be respected and an appropriate maximum numbers of permits should be determined. A German High Court has ruled that domestic security services could continue to treat the far-right Alternative for Germany (ADF) as a potentially extremist party, meaning they retain the right to keep it under surveillance. The federal officer for the protection of the constitution, charged with protecting Germany's democratic order from extremist threats, has classified the AFD as potentially extreme since 2021. Judges at the Higher Administrative Court in Windsor upheld a lower court's 2022 finding that the designation was proportionate and did not violate the Constitution or European or domestic civil law. Donald Trump's one-time fixer and the star prosecution witness in the former president's historic criminal trial testified that he lied and bullied for his former boss who looked on silently. Michael Cohen's testimony followed last week's court proceedings in which adult film star Stormy Daniels gave toe-curling detail about her alleged sexual encounter with Trump, which is at the heart of the case. Trump, 77, is accused of falsifying business records to reimburse his lawyer Cohen for a hush money payment to Daniels on the eve of the 2016 presidential election, when the story could have proved politically fatal. In the end, we have miscellaneous news. Senior advocate Kapil Sibal was elected as the president of the Supreme Court Bar Association (SCBA). The SCBA elections were held on Thursday. Mr. Sibal got 1,066 votes, while another senior advocate, Pradeep Rai, secured 689 votes on the post. Senior advocate Rachna Srivastava was elected to the post of vice president and advocate Vikrant Yadav as secretary of the association in the polls held on Thursday. A Harvard Law School graduate, Sibal was the additional Solicitor General of India during 1989 to 1990. He was designated as senior advocate in 1983. A review petition has been filed in the Supreme Court challenging the judgment of the EVM VVPAT case, where the prayers of 100% cross-verification of electronic voting machines data and voter verifiable paper audit trail (VVPAT) records was turned down. According to the review petition filed through advocate Neha Rathi, the court's April 26 judgment overlooked the vulnerability of symbol loading units (SLUs) and the necessity of their audit. Agarwal claimed that the possibility of additional data in the SLU beyond necessary images was disregarded by the court. It added that the judgment erroneously recorded that the percentage of VVPAT slips counted for the tallying with EVM votes is 5%, whereas it is less than 2%. The plea also contested a determination in the ruling that 100% matching of the EVM VVPAT data would cause a delay in poll results being declared. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.